Dear Chief Acosta, my wife and I have been residing in a small house that was built by my mother-in-law on a land owned by her best friend. The latter even executed a document for the use of her land by my mother-in-law for the time being. Unfortunately, my mother-in-law passed away a few months ago, and her best friend asked us to vacate the land because she plans to use it when she retires next year. I just want to know if we can continue staying on the house since the document has no period. If we cannot, can we demand for reimbursement for the house that was built by my mother-in-law? Melvin.
Dear Melvin, it appears that what exists between your late mother-in-law and her best friend is a usufruct. Under the new Civil Code of the Philippines, to quote,
Article 562. Usufruct gives a right to enjoy the property of another with the obligation of preserving its form and substance, unless the title constituting it or the law otherwise provides. Article 563. Usufruct is constituted by law, by the will of private persons expressed in act inter vivos or in a last will and testament, and by prescription.
as explained by our Supreme Court in Mercedes Moralidad versus Spouses Diosdado Pernes et al.,
Usufruct in essence is nothing else but simply allowing one to enjoy another's property. It is also defined as the right to enjoy the property of another temporarily, including both the jus intendi and the jus furendi, with the owner retaining the jus disponendi or the power to alienate the same.
it must be emphasized that, like any other rights granted under the law, a usufruct also extinguishes, and among the modes of extinguishment thereof is the demise of the usufructuary, unless a contrary intention clearly appears. So while we take into consideration that there may have been no mention in the document of a period for the termination of the usufruct in favor of your mother-in-law, it can be terminated by her death. Since your mother-in-law has already passed away and there is now showing that her rights as a usufructuary was transferable to her children or any other contrary intention, then it is submitted that the subject usufruct has already ceased. Consequently, your mother-in-law's best friend may demand for the return of her land. With respect to your query of reimbursement for the improvements made by your mother-in-law on the land, we submit that it may not be done as explained by the Supreme Court, and we quote,
If the builder is a usufructuary, his rights will be governed by Articles 579 and 580. In case like this, the terms of the contract and the pertinent provisions of law should govern. By express provision of law, respondents as usufructuary do not have the right to reimbursement for the improvements they may have introduced on the property. We quote Articles 579 and 580 of the Civil Code. Article 579. The usufructuary may make on the property held in usufruct such useful improvements or expenses for mere pleasure as he may deem proper, provided he does not alter its form or substance. But he shall have no right to be indemnified therefor. He may, however, remove such improvements should it be possible to do so without damage to the property. Article 580. The usufructuary may set off the improvements he may have made on the property against any damage to do the same.
we hope that we were able to answer your queries. Please be reminded that this advice is based solely on the facts you have narrated and our appreciation of the same. Our opinion may vary when other facts are changed or elaborated. Tomorrow, we'll look into another question from viewers and readers of Dear PAO. This is your host, Dr. Persida V. Rueda Acosta, DSD, the Chief Public Attorney of the Republic of the Philippines. Goodbye for now.